Hey, everybody. Patrick McQueen is in the house. Patrick, thank you so much for joining me today.
Thank you for having me, for sure. Thank you.
So for those of you that don't know Patrick, he's a local real estate attorney here in Arizona and always is so kind to share some of his time and insight with us to kind of tell us what's going on that real estate agents and people here in the community need to know. So I thought this one was interesting. Do you want to talk a little bit about laws affecting new construction, new residential construction, I'm guessing?
Yeah, that's primarily what we're going to talk about. So I'll start by saying it is rare that we actually get case law interpretations pertaining to new builds. And the reason that is because most new build contracts, either, the buyer isn't really trying to enforce them. They've sort of given up. Or number two, because there are very strong mediation or alternative dispute resolution, arbitration, those types of clauses in there. And so sometimes builder lawsuits don't see the light of day. And so it's rare that they do go all the way up to the Court of Appeals. It's rare that you get case law out of them. And so remember, I don't know if I've told you this before, but you get laws. We have laws come from two primary sources here in Arizona. Well, really three: the Arizona Constitution, but primarily from legislature. The legislature, so they create statutes, and then appellate courts. So the Arizona Court of Appeals or the Arizona Supreme Court, they basically make new law, case precedent, right? So we're going to interpret something, we're going to interpret a law, we're going to interpret documents, and then this becomes the law because at the appellate court level, we have that authority to do that. And so it's actually fairly rare that we get a case that, involves new builds for those reasons. And so they're going to be kind of significant, I think, when they do come down. So what we're talking about is a case, one of which is called the Zambrano case. And it went from the trial court to the appellate court all the way to the Arizona Supreme Court. And basically, what the courts ruled was largely that you cannot ask a buyer, you cannot have a buyer, or it's unenforceable if you attempt to have a buyer waive their implied warranties. Okay, so let's back that up a little bit, right? When you have a new build contract, right, and they're very one-sided, we all know that, but basically there are express warranties and there are implied warranties. Express warranties are those that are written into the contract. Hey, roof is going to remain watertight for 5 years. The air conditioning, HVAC is going to be guaranteed for 10 years. Roof for this, whatever, structure to whatever. And then we have implied warranties. And those are the things that it's sort of implied or implicit that these aren't going to happen. Like if you have stucco that runs off a wall after 4 or 5 years because it turns out that the builder used the wrong type of stucco, it's implied that shouldn't happen, and it's implied that you'll have a warranty to cover that. So we have the warranty of habitability, we have the warranty of good workmanship. Okay, so we're talking about warranties here. There's two primary types, and what we're talking about are those implied ones. Well, what a number of home builders were trying to do was they were trying to eliminate a buyer's ability to use an implied warranty. So you can't come after, you can only come after us for the express stuff. So if something happens to you, it turns out we used the wrong material and it gets you sick or stucco falls off or whatever, nothing you can do about it. Nothing you can do because it's not an express warranty thing. And it probably occurred, after the 2-year warranty period or 1-year warranty period or whatever you have. So builder was trying to, get people to waive that, and the court said no. And finally, so we now have some court interpretation that said, look, you guys are going too far now. I think that's the general reminder here is that you guys are going too far with some of these new build contracts. And the court also affirmed that there's really an 8-year statute of limitations for implied warranty claims. And that subsequent owners, so let's say you buy a new build and 3 years later you sell it to me. And then 2 years later, I discover an issue with the stucco or the foundation or whatever, that just something you didn't know about, nobody really known about, but it was just the wrong materials or whatever. Doesn't come out because the son had to take 5 years to beat it up, whatever. I can still go after the builder, even though I didn't have the original contract with the builder. you did, I can directly go to that builder. It's called a statute of repose, which is a little bit different than a statute of limitations, but basically it confirmed that there's an 8-year statute of limitations for implied warranty claims. Okay, so it applies to subsequent multiple buyers. And there has been a little bit of a trend, I would say. So this case came out, I don't know, a year ago or so, sometime last year. And there were also cases that were sort of building on this. There were builders that were asking the buyers to sign what's called like a no liability, like, hey, you can't sue us at all kind of clause that was unenforceable. And the rationale for all of this is that builders are in a better position to know what's wrong with the property than an actual homeowner. And so it's only fair that they take on this kind of risk and this kind of liability. So again, it's rare that these come up because the ADRE provisions are so strong and because people are so confused, because you look at one of these contracts and there's multiple remedy sections. I got to go to ADR, but there's also the Purchaser Dwelling Act here in Arizona, which says I have to give another notice to my builder, an opportunity to fix. And then we have the ROC statutes that say you can call the ROC and they can come in and make the builder or the subs do something different. So there's a lot of confusion as to remedies when it comes to new builds. And so we've got a little bit of clarification now, at least from this case. But my recommendation, if you're interested, is
always.
So if you're an agent and you are representing a buyer, a couple of things. Always put in writing, always urge these buyers to review those contracts and ask questions, because chances are they may be signing something that's unenforceable altogether. Okay. And they just don't know that. They don't know what they don't know. Always urge them to review the public report for the new build. Always urge them to get an inspection or multiple inspections at different points. Talk to an inspector about what those points are. But if you can kind of prevent problems before they occur, that's great. And the other thing is, always have your clients or suggest that your clients review title reports prior to closing, because what I've seen are situations where, you get an angry contractor who doesn't get paid the full amount that they're entitled to or at all. They throw a lien on the property. Now, normally in a lender finance transaction, that's going to get caught. But if we're paying all cash, it may not get caught. And so you may be stuck with a title issue. Final point for the new build stuff. I've seen this come up a couple of times in the last year and a half. It came up recently again. Sometimes we have different closes of escrow on new builds. Sometimes the builder closes early and then does something to finish the property. Sometimes we close on the land and then other things happen. But sometimes it's not the sort of traditional closing like we're used to. Reminder that your fiduciary duty as an agent ends at close of escrow. And so to the extent that you're helping a buyer, a new homeowner, go and enforce a remedy, you are re-triggering your fiduciary obligation. So you better get it right with whatever you're telling them. I've seen agents that get themselves into trouble because they're giving incorrect advice on warranties. They're giving incorrect advice on going to the ROC. They're sort of overstepping what it is they should be doing. Remember, it ends at close of escrow. You're going to re-trigger it if you start helping out and that sort of stuff. And so you better be right, or you better not do it at all. And so the advice that we usually give is, I want you to be friendly because it's good to be friendly to your buyers and your former clients, etc. But to the extent you're navigating the issues for them, you better be right, because you're now re-triggering the fiduciary obligation and you're not getting a commission for it.
That is such great advice. And, this stuff isn't always easy to get right. Some of these contracts, the way that they read and the interpretation is very much can just be an interpretation, not necessarily maybe what the legal interpretation or intent was. So I think in those cases is such a great reminder, Patrick, and thank you for sharing that. If that does come about, what's the best course of action for a real estate agent to do it? They all have serving hearts for the most part, and they want to help, but obviously staying in your lane is also important too. So what is your recommendation?
Are you referring to after the close of escrow?
Yeah.
I think you say, this is how I believe it works. I think this is okay to say. I think you can say, based on my experience, this is what I've seen. But you want to confirm that with somebody who knows, a real estate attorney, construction attorney, a tax attorney, or a CPA, whatever the issue may be. I think you can kind of be helpful and, hey, here's the contact information from the contract. Here's who I would contact, those kinds of things. I think that's perfectly fine to sort of help out because that's what a lot of us want to do. It's our nature to do it. But once we start giving specific advice, once we're the ones who are starting to reach out to the builder, we're now taking on that obligation and we better be doing it right. And again, even if we're doing it right, we're not getting paid to do it. So another reason to be right. But so to me, it's be helpful, but document that you are certainly giving a referral to the inspector or to an architect or to an attorney or to a CPA.
Yeah, that is sound advice. Patrick, thank you so much for sharing this information with us today. If people want to reach out to you too, maybe they are in this situation where it's post-closing and something's come up, how do they reach you?
Yeah, phone number is 602-767-0050. Our office is in Phoenix and Chandler. And our website, Medalist, MEDALIST legal.com. That's where you can find me.
Awesome. Well, thanks, Patrick. I appreciate you. I'll see you soon.
Thank you. Have a good one.